have a chance to know abroad and deeper about the business judgment rule, not in Indonesia, but this is an Australian perspective, so we can compare how the business judgment rules, what the definition, and then the application, and how it works in Australia. Well, for this session, I will give an opportunity to Mr. Tim to give speech and to the material around 40 minutes, and then after that we will enter the question and answer session until maximum 30 minutes, and then there will be a conclusion from Mr. Tim Kanner. Yeah, so because the time is already a little bit late and I don't want to wasting time anymore, so Pak Tim, the time and the screen is yours.
Thank you very much, Pak Setiawan. Can you see my screen okay? Is it showing?
Yes, yes.
Oh, fantastic. So as Pak Setiawan mentioned, my name is Tim Connor. I'm a senior lecturer here at the Newcastle School of Law and Justice at the University of Newcastle in Australia. And I know Pak Setiawan and Ibu Ninda well because both of them have visited our campus, and we had a great experience getting to know them and learning about more about Indonesian law, and also sharing some information about Australian law. Today, as Pak Setiawan mentioned, I will be talking about an Australian perspective on the business judgment rule. Maaf, saya bisa berbicara bahasa Indonesia sedikit-sedikit. So I will speak in English. I'm very sorry about that. I wish I could speak in Bahasa Indonesia. But if there are some questions at the end, perhaps Pak Setiawan might be able to translate the question and my answer, which may be more helpful. So first I want to paint or give some... First, I want to acknowledge that I am giving this lecture on the traditional land of the Awabakal and Worimi nations, and pay my respects to their elders past, present and emerging. Here at the University of Newcastle, we regularly do this whenever we give a presentation to acknowledge that my ethnicity, that white Australians, have taken land away historically from Aboriginal nations, and Australia, as you may know, is still struggling with how to deal with that past injustice. And we may have a referendum next year to talk about possibility of giving constitutional recognition to traditional owners of our land, and also an Indigenous voice to Parliament. So the University of Newcastle is very interested in how we can contribute to overcoming past injustice experienced by Indigenous people in Australia. And part of our custom is to recognise that we are operating on the traditional land of Awabakal and Worimi people. So I also wanted to share, because 40 minutes is quite a long time, but I tend to talk for a long time. So if I run out of time, many of the ideas I discuss in this lecture are also explained in a journal article that I wrote with Wes Bainbridge in 2016. It's called Another Way Forward, the Scope for an Appellate Court to Reinterpret the Statutory Business Judgment Rule. I'm happy to send a copy of that article to Pak Setiawan and Ibu Ninda so they can share it with anyone who is interested. It is, I think, the journal article I am most proud of, because it has been quoted by a judge of the High Court of Australia. So that hasn't happened to any of my other papers. So I am very proud of that. And I would be happy to share it if you're interested to read. The important thing is, or part of the background which is important to understand, is that almost every country in Australia, almost every country in the world, not every country in Australia, has what's called a duty of care, or in some countries or jurisdictions, it's called something different, but has the same meaning, where company directors are obliged to exercise their powers and discharge their duties with care and diligence. Now, I'm not an expert on Indonesian law, but when I was preparing for this lecture, I had a brief look at law number 40 of 2007 concerning limited liability companies. And I'm happy to be corrected because, of course, I know very little about Indonesian company law and I wish I knew more. But I think it is Article 97, subsection 3 of law number 40 of 2007, which talks about the importance of company directors in Indonesia acting without negligence and potentially being liable for any damage that results from the negligence. So in Indonesia, the language is in relation to negligence. In Australia and some other jurisdictions, it's framed as a duty to act with care and diligence, but it has essentially the same meaning as I understand it. So directors are obliged to do their job well and carefully, and if they don't do it well and carefully, if they are negligent, then they can potentially be liable to penalties or pay compensation to the company. And as you can imagine, that duty gives directors of companies some anxiety or concern that they may be liable for an honest mistake. They might be trying to do the best for their company and they might honestly make a mistake, and then they might find themselves liable to have to compensate the company. And because of that anxiety, in most, if not all jurisdictions, in addition to the duty of care and diligence, there is also what is often referred to as a business judgment rule, which is a rule that protects company directors from liability if their actions fall within the scope of the relevant rule. And the rule is different in every jurisdiction, so I can't give you a perfect formula for what the business judgment rule looks like around the world. But in general terms, a business judgment rule usually states that if directors are acting in good faith with the intention to do what is best for the company, and if they exercise a business judgment, so a decision that is relevant to the company's business, and they do so honestly, in good faith, and with some minimal level of diligence, then they will be protected from liability for breaching their duty of care. So whereas the duty of care often gives directors a lot of anxiety, in many countries, the business judgment rule relieves the director's anxiety and makes them feel much calmer. And in fact, in the US, in America, the business judgment rule is so powerful that it is almost never the case that directors are found to have breached their duty of care and diligence. Because the business judgment rule in the US is so strong and so protective of directors, it is actually very rare for directors to be liable. So what about in Australia? Before I talk about the business judgment rule in Australia, I would like to share some background information about company law in Australia and about the duty of care in Australia. It's important to remember that Australia is a common law country. So some of our laws are created by judges, and there are two traditions of judge-made law in Australia and the UK. They are the common law tradition and the equitable tradition. And so there are two parts to laws made by judges, the common law and the equity and equity. And in 40 minutes, I don't have time to explain all the differences between common law and equity, but the main thing I wanted to make clear is that in Australia, because we are a common law jurisdiction, some of our laws are created by judges. And even for those laws that are created by Parliament, by statute, when when judges interpret those statutes, the interpretation that a judge gives to a law made by Parliament can potentially bind other judges. So in particular, if an appellate court, so not the first court that hears the case, but if the case is appealed to a higher court, if that higher court decides how a law made by Parliament should be interpreted, then other judges, when they deal with that law, are expected to follow and apply the interpretation that the earlier judge had given. So what's called the law of precedent, which is the idea that judges' decisions can create law and then be binding on courts below them in the Australian court hierarchy, also applies to laws made by the government, by Parliament. So that's the first point. The second point is that in Australia, the director's duty of care is based on many sources of law. So there is a provision in statute, section 180 of the Corporations Act 2001, which sets out the duty of care as a statutory law, a legislative rule. But also there is both at common law as part of the law of tort, and also in the equitable tradition of judge-made law. The duty of care also exists in both of those branches of judge-made law. And finally, director's duty of care also in Australia exists as an implied term in the employment contracts of executive directors. So it has a number of different sources of law: statutory law, judge-made law, and contract law, the terms that are implied into employment contracts of executive directors include a requirement that an executive director will exercise their duty with care and diligence. Another thing that is different in Australia is that we have a government regulator that enforces the duty of care. So in many countries, it's only the company that has the power to enforce or take legal action if the director's duty of care to the company is breached. But in Australia, in addition to the company, also the government regulator, the Australian Securities and Investments Commission, or ASIC, also has the power to enforce directors' duties. And that power that ASIC has is not limited to the statutory duty, section 180 of the Corporations Act. ASIC can also enforce the common law duty of care and the equitable duty of care. So the role that ASIC plays in Australian company law is very important, and it makes Australia somewhat different from other jurisdictions. The other thing that's important to understand, particularly about the statutory duty of care, the one set out in section 180 of the Corporations Act, is that ASIC has the power to seek a pecuniary penalty of up to 1.1 million Australian dollars. So this is a big penalty. It's much bigger than was the case historically. It was increased from 200,000 Australian dollars to 1.1 million Australian dollars in 2019. And that happened as part of the government's response to the Financial Services Royal Commission. So in 2017 and 2018, there was a big government inquiry into some very bad practices in the Australian banking system. And some of Australia's biggest companies were found to have been behaving very badly, including breaching laws against money laundering, including charging their customers for services that they weren't providing. They did not provide the services, but they charged the company for the services. And also, even in some cases, they were found to have continued charging people after they had died for services they were not even delivering. So there was a whole range of quite shocking findings in that Royal Commission in 2018. And as part of the government's response to that Royal Commission, to try and restore faith, particularly in large companies in Australia, they increased the penalty for breaching Section 180 of the Corporations Act and other directors' duties up to potentially 1.1 million Australian dollars. Now, my picture is some US dollars. I'm sorry about that. I couldn't find a picture of Australian dollars, but I just wanted to make the point with the picture that the fines are very high. And so it's perhaps understandable that directors become very anxious that they may become liable if they breach Section 180. The other thing to really note about Section 180 being a civil penalty provision is that if ASIC or a company accuses a director in Australia of breaching Section 180, failing to comply with Section 180, then the standard of proof is only the civil standard. So if ASIC accuses a director of breaching their duty of care, then ASIC only has to prove on the balance of probabilities that it's more likely than not that they have breached their duty of care. So that is much easier for ASIC than if they were required to prove on the basis of the criminal standard of care, which is beyond reasonable doubt. So because the standard is only the civil penalty, it's another reason why directors can be quite anxious about this duty of care, particularly the duty in Section 180. Now I want to talk a little bit about the history of the duty of care, both in the UK and in Australia. And I've shown you a picture here of the Marquis of Bute. Now, the Marquis of Bute was an English lord, a very wealthy English person in the 1800s. And at the age of 6 months, so when he was still a baby, at the age of 6 months, he was appointed as a director of Cardiff Savings Bank. So presumably his father or some other person who had been on the board of the bank passed away. And at the age of 6 months, he was appointed to the board of the bank. And for the next 40 years, he remained as a director on the board of this bank, but he never attended any meetings, or he attended one meeting of directors. So over 40 years, he only attended one meeting. And then in 1892, when this bank came into a difficult situation and ran out of money, and the directors were sued for acting negligently, the Marquis of Bute, along with the other directors, was also accused of breaching his duty of care. And you would think that a director who has only attended one meeting in 40 years would be found to have been negligent and found to have failed to uphold their duty of care. But actually, the Marquis of Bute was found to not have breached his duty of care. And the reason was that the court took a subjective approach to the duty of care. So they said a director is obliged to act with the care and diligence that another director with the same knowledge of the company and the same expertise in relation to the business of the company would exhibit. And because the Marquis of Bute knew nothing about banking and knew almost nothing about the company because he'd only attended one meeting, the standard of care that he was held to was very low. So during this period, directors were not very anxious at all about breaching their duty of care because the court's approach was very generous. And even from 1925 to 1995, where the lead case in England and in Australia was the judgment of Justice Roma in the case of Re City Equitable Fire Insurance. But here as well, the position was that the question was, did the director act with the care and diligence that a person in the same position would do with the same knowledge and experience. So again, the question was not, has this director done what a reasonable director could be expected to do? Instead, the question was, firstly, how much knowledge and experience did this director have, both of the company's operations and of what was required of a director, and then their negligence or lack of negligence would be judged against that standard. So it, again, was a very low standard for directors to be held to. And that low standard continued in Australia, at least, until 1995. But in 1995, this case of Daniels and Anderson, which is often referred to as the AWA case, in 1995, that case was determined by the New South Wales Court of Appeal. So the New South Wales is one of the states in Australia, and their Court of Appeal is an appellate court, obviously. And so the decision of Clark and Scheller was an important decision because it was a decision by a majority of judges. There was only 3 judges in that case. So Clark and Scheller formed the majority. And they said the duty of care is a duty to take reasonable care in the performance of the office. So instead of comparing the director's skill and diligence with the skill and diligence of a director who had the same knowledge of the company as the director who was accused, the judges in the AWA case said all directors have to exercise reasonable care in the performance of their office. Now, that decision by the AWA case generated a lot of anxiety amongst directors. So the Australian organisation of Australian company directors, they spent a lot of time meeting with government representatives and lobbying the government and saying that we do not think this is a good idea for the duty of care to be increased, because it will make people afraid to be directors of companies, and it will reduce people's willingness to take risks. So the directors' organisation said, if this law stays, people will stop being entrepreneurial. People will stop taking risks, and you need people to take risks for businesses to, for the economy to develop and for innovation to take place. So they argued that this decision in the AWA case was a problem, and they called for Australia to introduce a statutory business judgment rule. Because at this time, Australia did not have a business judgment rule. But in the year 2000, and I'll show you the statutory business judgment rule in a moment, but in the year 2000, the government of the time, led by Prime Minister John Howard, agreed to introduce a statutory business judgment rule to protect directors if they were making a decision that was a business decision that they believed was in the best interests of the company. And I'll just take you to that rule now. So on your screen, if everything's working well, hopefully you should be able to see both section 180, which is called Care and Diligence, Directors and Other Officers. And it says, most importantly, that a director or other officer of a corporation must exercise their powers and discharge their duties with the degree of care and diligence that a reasonable person would exercise if they were a director or officer of a corporation in the corporation circumstances and occupied the office held by and had the same responsibilities as the director or officer. So section 180, subsection 1, apologies, I did not mean to do that. I'll just fix that up. Subsection 1 is basically an enactment of the decision in the AWA case. So the Parliament, for the standard of care or the duty of care, instead of saying the degree of care and diligence is the degree of someone who had the same knowledge of the corporation, it's instead a reasonable person who is a director or officer of that kind of corporation and has the same responsibilities. So it's an objective test, not a subjective one, and it's one that it applies to all directors and other officers of a company. Also, as I said, this section is a civil penalty provision, which is something that has generated a lot of anxiety among directors because of the penalties for civil penalty provisions that I spoke of earlier, and also because of the fact that the standard of proof is only the civil standard of a balance of probabilities. So the government, in addition though, when they revised the Corporations Act in 2000, they also introduced subsection 2. Subsection 2 is what's known as the business judgment rule. And it says this, and I won't go through it yet in very much detail, but I just wanted to highlight a few elements. So it says a director or other officer of a corporation who makes a business judgment is taken to meet the requirements of subsection 1 and their equivalent duties at common law and in equity. So it's not just the statutory duty in subsection 1, it's also the duty of care at common law and also the duty of care in equity. Then for that judgment, provided they meet these requirements in A, B, C, and D, then the director or officer's belief that the judgment is in the best interest of the corporation is a rational one unless the belief is one that no reasonable person in their position would hold. So here you've got a situation where Parliament has brought in a provision designed to alleviate directors' anxiety about the AWA case and about subsection 1, which is modelled on the AWA case. But interestingly, although this business judgment rule was introduced in the year 2000, its impact in Australian judicial decisions has been much smaller than expected. Now, although it's not exactly the same, this particular provision, subsection 2, is based on the business judgment rule in the US. And that's actually what the directors' organisation in Australia called for. They wanted the US version of the business judgment rule because, as I said, in the US, the business judgment rule is so effective in protecting directors that directors are almost never found by a court to have breached their duty of care. Now, in the US, the business judgment rule is a common law rule. It's not a statutory rule, but there is a law reform commission body in the US who has summarized the common law business judgment rule in the US. And the Australian rule was based, not exactly, but it's very similar to the summary of the American business judgment rule. And so it was expected that it would be highly protective of directors. But in fact, many people have claimed it's a failure. And the reason they claim it's a failure is because in all the cases where a director has been found to have breached subsection 1, 180 subsection 1, if in those cases where the director has then claimed that they should not be held liable for that breach because they satisfy the business judgment rule, in every case the director has failed. So in every single case, when a court has found that the Section 180 subsection 1 has been breached, the court has then denied the director the protection of 180 subsection 2. So the Australian Council of Company Directors and many commentators have said that the statutory business judgment rule in Australia is a waste of time. And they've called for it to be reformed. Now, in the article that I and Wes Bainbridge wrote, we questioned whether it had been a failure, because when we looked at the history of the making of that law, and we looked at some of the statements made by people involved in making the statutory business judgment rule, many of them were saying this provision is there primarily to reassure directors. They were saying, actually, the common law in Australia and the interpretation of the statutory rules in Australia is actually already very similar to the US business judgment rule. So we're not introducing this statutory business judgment rule actually to give extra protection to directors. We are doing it to reassure directors that the same protection that directors in the US have is available to directors in Australia. So if that was their reasoning, if their reasoning was that Section 180 subsection 1 is already as generous to directors as the business judgment rule, then the purpose wasn't to give extra protection, it was just to give extra reassurance. And that's the argument that Wes Bainbridge and I make in the article. And you may or may not agree, but it's generated some interesting debate with other academic commentators. But the other thing we argued in that article is that we don't think the case has been properly interpreted. And the main court case in Australia that has interpreted this provision is the decision of Justice Austin in 2009 in the case of Australian Securities and Investment Commission v. Rich and another. So ASIC had taken a director named Jody Rich to court. Jody Rich was director of a mobile phone company called OneTel. OneTel had collapsed and many investors had lost a lot of money. ASIC alleged that Jody Rich and the other directors of OneTel had breached their duty of care, and Justice Austin was the judge appointed to decide the case. Now, Justice Austin is only a single judge on the Supreme Court of New South Wales when he made this decision. So his interpretation of Section 180, subsection 1 and subsection 2 is not binding on other courts because he was only a single judge hearing a decision at trial. However, Justice Austin is one of the most famous, if not the most famous, company law judge in Australia. So even though he only sat on the New South Wales Supreme Court, he had also been an academic at a very prestigious university in Australia. He also is the co-author of the most prestigious company law textbook in Australia. And because he is so well regarded and so famous as a company lawyer and a corporate law judge, since his decision, other judges have followed his approach and have interpreted Section 180, subsection 1 in the same way as Justice Austin. And what Wes Bainbridge and I argued when we presented our journal article was that we think, although we agree with some aspects of Justice Austin's interpretation of Section 180, subsection 1, we also disagree with some other aspects. And we believe that if a case on Section 180, subsection 2 reaches an appellate court, we would recommend that certain elements of Justice Austin's interpretation should be overturned by the appellate court and replaced with different interpretations that are more sympathetic to the directors, in fact, and directors who are accused than the interpretation that Justice Austin took. Now, I know I only have 5 minutes left, so I'll just give you one example, but it's probably the most important example, and it illustrates something about the way decisions are statutory interpretation occurs in Australia. So we can see here that, I'm not sure why that, there we go. So subsection 2 says a director or other officer of a corporation who makes a business judgment rule is taken to meet the requirements of subsection 1. So subsection 2 says, if they do the things set out below, i.e. A, B, C, and D, then they're taken to meet. They're treated as if they have already satisfied the requirements of subsection 1. So they're treated as if they have acted with diligence, and they won't be liable for a breach of their duty of care. However, it's not entirely clear from this wording whether subsection 2 is intended to be a defence that directors can rely on, or a presumption that is available to directors to plead even before subsection 1 is considered. And that distinction is quite important, because if subsection 2 is a defence, then directors are not allowed to plead subsection 2. They're not allowed to argue in court that subsection 2 applies to them until the court has first found that the director has breached subsection 1. So if it's a defence, the process is the court will hear arguments about whether the director has breached subsection 1. If the court determines that the director has breached subsection 1, then the director has the opportunity to plead the business judgment rule and claim that they shouldn't be found liable because this defence protects them. So the order in which things happen is different than if it's a presumption, because if it's a presumption and not a defence, then the director from the beginning of the case can say to the court, I am going to plead the business judgment rule. I believe I satisfy all of the requirements of the business judgment rule, and therefore the court doesn't even need to consider whether I have breached subsection 1 because I am protected by subsection 2. And the reason that is, the other reason why this is important is because of the onus of proof. Now, if it's a defence, the director has the onus of proof. So the plaintiff, whether it's ASIC or the company, first have to prove that the director has breached their duty of care. And then if the director wants to plead the business judgment rule, it will be up to the director to persuade the court that each of these elements of the duty have been satisfied. So the onus will lie with the director to persuade the court. On the other hand, if it's a presumption, the onus will lie with ASIC or the company, i.e. with the plaintiff, to prove to the court that these 4 elements do not apply. And because it's quite complicated, the interpretation and application of the business judgment rule, because of that, it's much more helpful to directors if it's a presumption rather than a defence. And in the US, it is absolutely a presumption. In the US, the court first considers whether the business judgment rule applies, and it's only if the court finds that it doesn't apply that it then considers whether the duty of care is breached. And in the US, it's very much the case that the plaintiff, so the company particularly in the US, has the onus of persuading the court that the business judgment rule does not apply. However, Justice Austin in this case, and he said with some reluctance, given the situation in the US, decided that this provision operates as a defence. So ever since that decision, ever since 2009, every time a business judgment rule, the business judgment rule is discussed in court, it is argued as a defence by the director, with the director already having been proven to have breached subsection 1, and the director having the onus of proving that they should be protected by subsection 2. And the reason, I'm out of time, I know, so I won't go into it in detail, but the reason Justice Austin argued that is because, first of all, he said it's not clear from the text of the provision whether it should be a presumption or a defence. And then he said, and even if we look at the parliamentary documents, the documents that Parliament released when they released this law, they don't explain either whether it should be a presumption or a defence. And he actually spends a lot of time discussing subsection 4 of the relevant explanatory memorandum for Parliament and saying that that doesn't clarify it. But Wes Bainbridge and I point out that actually the judge made a mistake and didn't consider subsection provision 10 of the explanatory memorandum, which very clearly states that subsection 2 should be a presumption. So we would argue that, first of all, the fact that it's hasn't led to directors escaping liability is not necessarily indicates a failure, but also we believe it has not been properly interpreted, particularly because it should be interpreted as a presumption in favour of directors and not a defence. I know I need to finish now, but I just wanted to quickly mention that if you're interested in studying here at Newcastle after you complete your undergraduate studies at Brawajaya, for those of you who are, we studying undergraduate level, we offer a Juris Doctor graduate diploma of legal practice, which one of a graduate from Facultas Hukum UB is currently studying. And we also have an articulation arrangement with the Master of Laws, with Universitas Brawijaya's Master of Laws. So you can potentially complete 1 year of the Brawajaya Master of Laws and 1 year of the Master of Laws in Newcastle and get 2 master's degrees. Or you could complete 1.5 years of the Master of Laws at Brawajaya and half a year, 1 semester with Newcastle, and again get 2 masters, one from Universitas Brawajaya and one from the University of Newcastle. Okay, so I'll finish now. I know I went a little bit over time. Apologies for that. And I look forward to hearing your questions.
Okay, thank you very much, Pak Tim, Mr. Connor. So I saw there are several questions in the chat column, but I must apologize first because at the beginning of your presentation, there is one participant who raised his hand, but I forgot because it was a glance that the raised hand icon was so quick, so I cannot mention in full about the participant who raised hand. So yeah, maybe I will try in bahasa first. Tadi peserta yang di awal presentasinya Pak Tim raise hand siapa ya? Saya kelewatan tadi, ada satu yang raise hand. Dia ada di awal. Nggak ada yang ini. Oke, kalau nggak ada atau ini gini aja. Ya, sudah ada pertanyaan. Pertama dari Mas Benny dan kedua dari Mbak Satya. Mas Benny ada hadir? Bisa ini mic-nya? Oke. Mas Benny. Oke. Okay. So sorry, Mr. Tim. So I asked the participant who wrote the question in the chat column to Mas Benny. Yeah. Is Mas Benny exist? Hello, Mas Benny. I didn't see the name in the participant column. So okay, maybe I will just okay, quite a long question, but first of all, Benny Hutayan wants to thank you for the presentation, Mr. Tim. But also, Mas Benny is as okay.
Excuse me, Pak Setiawan.
Yes.
I can read Pak Benny's question. So perhaps if you just translate it into Bahasa Indonesia, and then I can answer.
Yeah, so okay, I will choose Indonesia. Jadi untuk partisipan gitu ya. Jadi Mas Ben ini sebenarnya bertanya terkait dengan ini sih, penjelasan lebih lanjut aja gitu ya terkait dengan perbedaan antara duty of care sama business judgment ya, khususnya di private company di sini yang di-compare juga dengan perusahaan milik negara ya. Jadi bagaimana sih duty of care dan business judgment di perusahaan swasta dan duty of care dan business judgment di perusahaannya BUMN, kurang lebih seperti itu. Terus kemudian juga terkait dengan ya kalau di BUMN atau ini itu resikonya memang salah satunya adalah kalau nanti salah itu memang bisa dihadapkan dengan tuntutan korupsi gitu ya. Nah, itu karena kaitan dengan keuangan negara. Jadi itu yang ditanyakan dengan Mas Benny. So I'm sorry Mr. Tim. So do you want to answer the question from Benny Hutayahan right now? Yes.
Yeah.
Okay, I will give you time, Mr. Tim.
Great, thank you. I might quickly share my screen again and show you the section 180. First of all, I'd like to thank you, Pak Benny, for your question. It's an excellent question. So the duty of care set out in the Corporations Act applies to all corporations. So Section 180, subsection 1 says a director or other officer of a corporation. So it does not only apply to private companies, which is one category of corporation, it also applies to state-owned corporations. So the same duties and obligations that apply to directors of private companies also apply to public companies. Now, there are some additional obligations that apply to directors of public companies. For example, there are some requirements in the Public Services Act. So because directors of public government state-owned corporations are regarded as public servants, they are subject to some of the provisions of the public service legislation in Australia. But they also, sometimes it's possible for there to be duties that are linked to the legislation that creates the particular state-owned corporation. So, for example, most universities in Australia are state-owned corporations, and they are created by their own piece of legislation. So, the University of Newcastle was created by the University of Newcastle Act in the 1960s. And it's possible for those individual pieces of legislation to put additional obligations on directors and officers. But most commonly, and the duties are the same for directors and officers of private corporations and public corporations. One distinction, though, with Australia and what it sounds like the case in Indonesia is that the duty of care, so Section 180 in Australia is a civil obligation only. So if you breach the duty of care, you cannot be sent to jail for a breach of duty of care, for acting without care and diligence. However, some of the other duties of directors have criminal sanctions as well as civil obligations. And those particularly most famously are set out in Section 184. So if a director, this is Section 184, subsection 1. So if a director or other officer of a corporation commits an offence if they are reckless or are dishonest and fail to exercise their powers and discharge their duties in good faith in the best interest of the corporation and for a proper purpose. And if a director of a public corporation or a private corporation was to act dishonestly and corruptly, then they would satisfy subsection 1 of section 184, and they could potentially be sent to jail for that breach. So effectively, it sounds like the situation is similar, but it's governed by section 184 rather than section 180. Does that help with the answer? I'll just stop sharing the screen.
Yes. Thank you, Mr. Tim. And also there are two participants, Sultan Saki and Sahira. But first, I want to ask to Sultan and Sahira first. Does the question related about this question, or this is a new question?
It's entirely a new question for me.
Okay, and Sahira, is it related with the Benny's question, or is a new question?
It's a new question, sir.
I'm sorry, your voice is your volume is low, Sahira.
I'm sorry, it's a new question, sir.
Oh, new question. Okay, so I will give opportunity for Sultan and Sahira later. Okay, I'm sorry. Okay. Yes. So that's the Mr. Tim question answer from the Mr. Benny Huta Hayan. Yeah. So this is a very interesting. I didn't know much about this, but of course in Indonesia, in state-owned company is very serious. Yeah. In like gasoline, Pertamina, the manager, and also in forestry and land law. Yeah, so the land owned by some state-owned company. Well, if you give the wrong management, and they will face corruption or something, because it's related with the state financial, etc. So it's very interesting in Indonesia. Okay, Mr. Tim, thank you for the first answer. Yeah, for the first question. There's still a question from Satya Pungkasandi. Is Satya is in here? Sorry, Satya. No, or maybe okay. So it's a quite a long question from Satya. So, Mr. Tim, do you want to directly answer the Satya Pungkasandi question?
Yeah.
Okay, the time is yours, Mr. Tim.
Terima kasih. I am just reading to the end. Okay. So in Australia, I think this question in some ways is similar to the previous question. So yeah. in Australia, section 180 is, sorry, I'll just share my screen again. So section 180 is applying to directors of public companies, state-owned companies, as well, state-owned corporations, as well as to directors of private corporations. And for both, the business judgment rule applies to protect them in respect of a business judgment. But this is another aspect of the interpretation of a business judgment, or there is another aspect of the interpretation of this provision that I think is relevant here, and that is the interpretation of this phrase, a director or other officer of a corporation who makes a business judgment. And when the courts have interpreted this phrase, makes a business judgment, they've been very clear that if a director deliberately decides to break the law, so if a director, for example, deliberately acts in a corrupt way, or deliberately causes their company to break the law, even if they're not themselves acting corruptly, that does not count as a business judgment. So in Australia, that kind of corruption or criminal activity or deliberate law breaking will not receive the protection of the business judgment rule, whether it's a state-owned enterprise or a state-owned corporation or a private company. If it's a decision that involves the director themselves breaking the law or deliberately causing the company to break the law, then there's no protection from subsection 2, because the courts have said that is not a business judgment, it's a compliance judgment. And the courts have said a compliance judgment should not receive the protection of the business judgment rule. But so even though state-owned enterprises and state-owned corporations also have this protection, it's important to have that qualification that if it's involves breaking the law, it does not get the protection of the business judgment rule. And the other point is just the one I made earlier, that it is still possible for directors to be sent to court for breaching Section 184, subsection 1. And this provision, Section 184, subsection 1, applies to all directors, whether they are directors of a state-owned enterprise or a state-owned corporation or a private company. And the business judgment rule does not apply to Section 184. So the business judgment rule only applies to Section 180. So if directors breach this provision, if they're dishonest and they don't act for the best interest of the company, then they can be sent to jail and they're not allowed to plead the business judgment rule in relation to Section 184. Does that answer the question, Satya?
Yes, Mr. Tim. But maybe related to the question is so the definition of business judgments. I think it's very subjective, right? Between me and Mr. Tim about the situation. They're facing, there are possibilities that we will have a different decision about that. So if my decision, I think it was a good, good management, a good decision. But when we do that, so we execute it, and then there is a loss from the it could be in the state or maybe in the company, and then maybe in the judge will say, you're doing the wrong, the wrong management. You did not fulfill this judgment. But I say, when I make that decision, I already analyzed the situation, and it was a good decision according to me. So in a sense, is there something happening like that?
Yeah, that's a really good question, Pak Setiawan. And I might share my screen again just to talk it through. So if we go back to Section 180, both in relation to Section 180 and in subsection 1 and subsection 2, which is the business judgment rule, courts have been very clear that the judge has to put themselves back in the situation when the director made the decision. So lots of judges have warned other judges, you cannot only view this with the benefit of hindsight. You cannot only look at the result of the decision and decide it's a bad decision. You have to go back to the point in time in which the director made the decision, and you have to consider whether at that point in time, it was possible. It was possible for the director would rationally believe, so have reason to believe that the judgment was the best for the company. So that concern that you raised, Pak Setiawan, about the judge sort of looking at the result of the decision and saying, okay, it was a bad decision because it had a bad result. The courts in Australia have been very clear that judges are not allowed to do that. They can't focus on the result of the decision. They have to focus on the point in time in when the director made the decision. And they have to say, at the point in time when the director made the decision, is it reasonable that a director could have thought at that point in time that this decision was the best decision for the company?
Okay, thank you, Mr. Tim. So now I will give time for Sultan Zaki. Okay. Oh, is it freeze? Sultan Saki? Okay, he's back. Yes, Sultan Saiki, you can unmute your microphone.
Okay, can you hear my voice?
Yes.
Okay, thank you. Thank you for the opportunity to ask Mr. Setiawan. First, the presentation are very enlightening, Professor. My name is Zaki, final year student, currently taking concentration in business law. I was one of Mr. Setiawan's student in the first semester's introductory course, but now I'm Miss Ninda's student in one of her classes, which is the bankruptcy class. Professor, I'm a fan of one of your research, the typology of legal, regulatory, and voluntary initiatives to address gender balance on corporate board. It was very interesting in research. You addressed the lack of an agreed means of categorizing such initiatives which relate to effectively comparing their merits. I think my question is a little out of topic, but maybe it can be related in some way. So I once had the chance to read one of the reports from the OECD about competitive neutrality in Australia's SOEs. So the concept of competitive neutrality relates to a drive to ensure that in situation where public enterprise and private enterprise compete or could potentially compete in relation to the provision of goods and services in the market, both the public entities and private entities are essentially subject to the same external environment where this is in the public interest. From my readings before, I recently found out the intent of the competitive neutrality reforms was to modify the relevant external environment and the interrelationship between the relevant entity and its stakeholder so that broadly each of the entities would operate in a similar environment with similar responsibilities and goals. This enabled service to be priced at competitive rates, thus reducing inefficiencies, which in turn allowed the relevant market to operate according to competitive market principle on a level playing field with the aim of producing economic and employment benefits. And I firmly believe from my recent readings that the factors behind Australia's apparent success because of a reform program that applied both to SOEs and to specific industries, the flexibility to apply the framework differently in different geographic contexts, encouraging the commitment to competitive neutrality in strong administrative process, regular reviews, and reporting by individual jurisdictions on the progress of the reforms. So my question is, in relation to the business judgment rule that you have talked about, can the concept of the competitive neutrality be an enabler in creating the same level of playing field for the SOEs when it faces the private sectors in doing business? And could it be the answer to the problem of SOEs operate and their boundaries as part of state-owned? Because I personally believe that the problems that Indonesian SOEs facing right now are because of the way SOEs operate are like private sectors, which to get profit, right? But at the same time, they are enforced with many regulations that limit their capabilities and playing field. Because I believe with the advantage of being SOEs, they should be able to develop further rather than being chained to such regulations. So what's your views on this? Thank you.
Yeah, Sultan, that is a fantastic question. So I really appreciate the question, and it raises a lot of different issues, which some of them I will need to think about some more. I do want to provide some context, though. In Australia, there has been over the last 30 to 40 years quite a big program of privatization of SOEs. So historically, one of our biggest banks, the Commonwealth Bank, was a state-owned enterprise. But in the 1990s, it was privatized and no longer operates as a state-owned enterprise. Similarly, our national airline, Qantas, was previously a state-owned enterprise, but I think more than 20 years ago, it was privatized and now runs as a private business. And the same story applies in lots of different state-owned enterprises. A lot of them have been privatized. Not all, of course. So in the education sector, of course, you could potentially regard universities as state-owned enterprises that compete with private universities. So it's not universally the case that all our state-owned enterprises have been privatized, but it has happened in a lot of different sectors. And I personally believe that is a shame. I personally believe that state-owned enterprises can play an important role in markets, and that diversity of business structures is actually a positive thing. So when the Commonwealth Bank, for example, was owned by the national government, owned by the Australian government, it operated quite differently to private banks. It offered a very low interest rate, but was much more conservative in its lending. So it was then able to provide home loans to people who probably would not have been eligible for home loans in the private sector, but who could provide evidence that they were reliable and were able to pay. So in my view, I don't actually agree with the Australian government's competition policy, which is to try and make every enterprise operate the same and with the same priorities. I actually think a diversity of business structures and a diversity of business systems of regulation is actually positive. And this is perhaps somewhat of a tangent, but somewhat similar as well. I also believe that Australia's competition policy has been very damaging for cooperatives and mutuals as an alternative business structure. And I actually think cooperatives and mutuals have a lot to offer as well as a way of structuring business. But for example, the big competition law reforms in Australia took place in the 1990s. And before that, like up until the 1990s, in some agricultural sectors, such as the dairy industry, 90% of Australian milk products were made by cooperatives. So dairy farmer cooperatives basically controlled the Australian milk production and dairy product production and distribution. But following the introduction of the competition law reforms in the 1990s, those structures were not able to compete, and almost all of those cooperatives have now been purchased by big multinational corporations, and the farmers have much less control over the price, much less control of reliability of income, and are subject to incredible competitive pressure from these big multinational distributors, such that it's difficult for them to protect their farmland. So I realize your question was very broad and I've made it even broader, but the short answer is I think diversity of business structures and diversity of business goals is actually a good thing. And I disagree with some aspects of Australia's competition policy.
Okay, thank you, Mr. Tim. So is there any something you want to ask again, Sultan? Or maybe something more clear? Or it's enough? Okay, it's enough. Okay, then I will change to Sahira. Okay, Sahira. Yes, you can unmute and orally state your question.
Okay, thank you for the opportunity, Mr. Setiawan. Good afternoon in Indonesia, Mr. Connor. I am Zahira. I'm from the 5th semester, Brawijaya University. I'm a law student and I'm one of the students of Ms. Ranitya Ganinda and Mr. Setiawan Wijaksono. I actually have one question. This is regarding the example that you've been explained before. So in Australian perspective, how far business judgment rule can give the protection to the directors of the company, and what is the boundaries of business judgment rule in criminal law perspective? Because by the example about the directors of Pertamina that have done the fiduciary duty and didn't have any mens rea to do a corruption act, but by the judge, it is considered to be a criminal act of corruption. So if we look from the business judgment rule perspective, how far it can give the protection to the directors of the company and the boundaries if we compare it with the criminal law perspective, especially in Australia. Thank you.
Okay, thank you very much. Okay, Mr. Tim.
Thank you, Sahira. I might share my screen again. So this is an excellent question. One thing to always remember is that the duty of care and diligence that directors have in Australia is only a civil obligation. So the breach of the duty of care in Australia can only give rise to civil implications. It cannot give rise to criminal action. And the business judgment rule in Australia only applies to subsection 1 and the equivalent duties at common law and inequity. So the duty of care and diligence is only a civil obligation under statute in section 180 and in common law and equity, and the business judgment rule only applies to subsection 1. So in Australia, if the activity is criminal, then it won't be covered by section 180 and it won't be protected by the business judgment rule. However, there is under section 184 a criminal, well, there's a couple of criminal provisions. So subsection 1, if a director or other officer, or a director or other officer commits an offence, i.e. a criminal offence, if they are reckless or dishonest and they fail to exercise their powers and discharge their duties in good faith in the best interest of the corporation or for a proper purpose. And it's important there to note the mens rea for this offence is not intentionally or knowingly committing the offence. It is that they act recklessly or dishonestly. So if they act dishonestly, the implication is that they do it deliberately. But it's also possible for a director to be found criminally liable if they are reckless about whether or not they're acting in good faith. So if they don't care or don't take sufficient care when considering whether what they're doing is in the best interest of the company, then they can be found guilty as criminals, like a criminal prosecution, based on the mens rea of recklessness. Also, it's worth noting that subsection 2 says that if a director or other officer or employee of a corporation commits an offence if they use their position dishonestly with the intention of directly or indirectly gaining an advantage for themselves or someone else. So this is dealing with corruption, I guess, if it's in a state-owned corporation, and I'm not sure if you'd call it corruption for a private company, but if the director does it dishonestly and they use their power within the company to benefit themselves, then or their family or their friends, then, and they do it dishonestly, either they intentionally do it, then they will have committed a crime under subsection 2. But subsection 1, they only have to be reckless about whether what they do is the best for the company, and that they can be criminally liable in that situation. Does that answer the questions here?
Okay. Okay, thank you, Mr. Tim. Zahira, this is enough.
It already answered my question. Thank you, Mr. Connor, for the answer.
Thank you,
You're most
Zahira.
welcome, Sahira.
Yes. So, okay, maybe there is a time for one more question. If there is still a participant who wants to ask, this is the last opportunity because the time is almost at the end of this session. Or maybe Mr. Tim, do you want to add something? Yeah, because yes, you can add something because when you give your material, yeah, your lack of time.
Yeah, sure.
Yeah.
So I'll share my screen again. As I said, just briefly, I would encourage anyone who's interested potentially at studying at Newcastle to consider studying with us, particularly if you do a Master of Laws after you complete your studies at Universitas Brawijaya. There's that possibility of getting a joint Master of Laws with 1 year at Brawijaya and 1 year at Newcastle, or 1.5 years at Brawijaya and half a year at Newcastle to get 2 Master of Laws degrees. So you might be interested in joining us for 6 months for that, or there have been several graduates from Universitas Brawijaya who have studied our Juris Doctor program. But particularly, just to finish in relation to the interpretation of this business judgment rule in Australia, there's been quite a lot of debate about how to interpret each of the elements of the provision, but one that has particularly been controversial is this one. So the director must rationally believe that the judgment is in the best interest of the corporation. And then it says the director's or officer's belief that the judgment is in the best interest of the corporation is a rational one, unless the belief is one that no reasonable person in their position would hold. And it's often when parliamentary drafters are drafting provisions, they're not always as clear as they could be. And this part of the statutory business judgment rule has generated a lot of confusion among judges, because judges have said, if it's rationally believing, and it's irrational unless it is rational unless it's one that no reasonable person in their position would hold. Some judges have said, as Justice Austin did in the Asic and Rich case, that how is that then different from subsection 1, which says that you have to show the degree of care and diligence that a reasonable person would exercise? Isn't it just saying the same thing to say that it's rational if it's one that it's not rational if it's one that no reasonable person in their position would hold? So Justice Austin said, well, there's only two categories. Something can be reasonable or not reasonable. And there's nowhere in the middle. Like, it has to be either reasonable or not reasonable. So how are we supposed to interpret this idea that you can rationally believe it and it's regarded as rational if it's a belief that's not regarded as rational, like if it's one that no reasonable person would hold? But Wes and I, in our article, we said that although strictly in terms of the rules of logic, Justice Austin is right. So the question of whether something's reasonable or not reasonable is usually either or. Either it's reasonable or not reasonable. Actually, in Australia, there is quite a long tradition in different areas of law, and including in company law, for judges to suggest that there are degrees of reasonableness. So it's not just that something's totally unreasonable or totally reasonable. There are sometimes situations where it's probably a little bit unreasonable, but it's not so unreasonable that no reasonable person would hold it. So we argue that the intention of Parliament here, based on that history, is to be more generous to directors and say, the question is not, would a reasonable director have made this decision? But instead, is this a decision that it's so irrational that no reasonable person could have made it? And if it's that unreasonable, then the director could be liable. So this is very technical discussion of English. So I think it would be very difficult to understand if English is not your first language. But the basic idea that we argue in our paper is that the intention of Parliament was to be more generous to directors and give them more flexibility when deciding if what they decided to do was rational and reasonable.
Okay, thank you, Mr. Tim, for the additional. So I have to say I'm so very, very sorry because we already arrived at the end of the session. But maybe first, as usually, I want to ask the committee first. Are we gonna have take a picture? Yeah, there's a photo session. I'm sorry. Usually,
I think for the last year we have to take picture with all of the participants and also Pak Tim Connor. Once again, thank you very much, Pak Tim, for your availability to teach. I really appreciate it. Thank you. And also thank you for the students.
You're welcome, Ibu Ninda. And also, I will send a copy of the full journal article to you and Pak Setiawan. And if anyone has further questions, you can share my email address with them and they can send to me.
Thank you. Okay. So Belinda, mungkin saya aja yang ambil ya teman-teman mahasiswa. Jadi saya mulai dari slide 1, smile everyone. Okay. 1. So I go to the next slide. We have 4. Okay, second. Okay, smile everyone. And the third screen. Okay, so everyone in the third screen, smile. I see Edo here. And the last one. Okay. Thank you.
Okay, sit. Okay. Yes.
Thank you, Pak.
Everyone, can you give applause or emoji? They say emoji to Mr. Tim Connor, for the lecture this afternoon. Okay, thank you. I want to say thank you, Mr. Tim Connor, for the lecture this afternoon. This is a great opportunity for us to know about the business judgment rule in Australia, and of course, as an knowledge for us. Maybe they can write for the final assignment. Okay. Okay, then because we already arrived at the end of the session, so I would like to say formally thank you to Mr. Tim Connor for the material and the time this afternoon, and also to the participant who already joined in this Zoom. I hope we will meet again in another opportunity. Let me say Assalamualaikum warahmatullahi wabarakatuh, and this session is officially closed. Thank you, Mr. Connor.
Thank you, everyone.
Thank you, Bu Ninda, peserta semuanya, mahasiswa. Aku live ya. Bu Ninda, aku live ya.
Terima kasih ya, Mas Yawan. Terima kasih teman-teman semuanya.